मैंने बताया है कि उनके समन कैसे गैरकानूनी है, लेकिन उन्होंने मेरी एक भी बात का जवाब नहीं दिया। इसका मतलब उनके पास मेरी बातों का जवाब नहीं है। इसका मतलब वे भी मानते हैं कि उनका नोटिस गैरकानूनी है। क्या मुझे एक गैरकानूनी समन का पालन करना चाहिए? अगर कानूनी रूप से सही समन आएगा तो मैं पूरा सहयोग करूंगा।
Delhi Chief Minister Arvind Kejriwal has cited Rajya Sabha elections, Republic Day celebrations and the Enforcement Directorate's non-disclosure and non-response approach as reasons for not appearing for questioning.
बीजेपी का मकसद जांच करना तो है ही नहीं। इनका मकसद तो लोकसभा चुनाव में मुझे प्रचार करने से रोकना है। ठीक लोकसभा चुनाव के पहले इन्होंने मुझे सम्मन भेजा है। क्यों? इस जांच को चलते 2 साल हो गए। अभी ठीक लोकसभा चुनाव के पहले मुझे क्यों बुलाया जा रहा है? पहले क्यों नहीं बुलाया? सीबीआई ने मेरे को 8 महीने पहले बुलाया था। मैं सीबीआई में गया था, उनके सारे जवाब भी दिए थे। लेकिन अब ये लोग ठीक लोकसभा चुनाव के 2 महीने पहले मुझे बुला रहे हैं। तो बीजेपी का मकसद कोई पूछताछ करना थोड़ी है।
So, what happens now? What are the provisions under which the ED issues summons? Will he be arrested for failing to appear before the ED? Let's find out in this video. In his earlier responses to 2 such summons, Arvind Kejriwal alleged in his letter that the summons were issued at the behest of the Bharatiya Janata Party and said it was unclear in which capacity he was being summoned. First, is Enforcement Directorate supposed to reveal whether a person summoned is an accused or a witness? The provisions of the Prevention of Money Laundering Act under which summons are issued nowhere mention that the investigating agency must declare that the person being summoned is an accused or not. In fact, the provisions are not clear whether the summons are to mention the grounds for questioning of a person. In practice, however, Enforcement Directorate always mentions the case in which a person is being summoned to give evidence. Summons for interrogation are issued by Enforcement Directorate under Section 50 of the PMLA. According to the provision, the Director of the ED for the purposes of investigations has the power of civil court for inspection. Now, that also enforces the attendance of a person compelling the production of record, receiving evidence on affidavits, etc. Here's what the provision reads, quote unquote. The director, additional director, joint director, deputy director or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of any investigation or proceeding under this act, and all the persons so summoned shall be bound to attend in person or through authorized agents as the ED officer may direct them to do. The law has provision for penalty of up to 10,000 rupees and invocation of Section 174 of the IPC. This also stipulates a jail term of 1 month and or a fine of 500 rupees in case of non-appearance against Enforcement Directorate summons. Under Section 63(2)(c) of the PMLA, if a person refuses to respect the summons issued by ED or refuses to produce documents or evidence as demanded by the agency, they will have to pay a sum which shall not be less than 500 rupees, but which may extend to 10,000 rupees for each such default or failure. To arrest a person under Section 63 of the PMLA, the ED would have to get fresh case registered under Section 174 of the IPC and followed by a trial. Historically, the probe agency has never followed this route. The other legal route is to get non-bailable warrants issued against the person refusing summons. However, sources said this would not be easy since most of those refusing summons, including Arvind Kejriwal, gave written reasons for non-attendance. Enforcement Directorate would have to convince the court that the non-cooperation is deliberate and there is prima facie evidence of the person being involved. Also, court judgments have held that Section 50 does not allow ED to arrest a person summoned by it. There are no extant provisions in the PMLA to arrest for non-cooperation. There is also no limit to how many summons the agency must issue before reaching the conclusion that the person summoned is not cooperating. The law is clear that an arrest can be effected only if the officer is convinced that the person is guilty of the offence of money laundering.